October edition of the Residential Property Forum for Northern Ireland. Could I remind you that these forums are recorded, and if you missed the last one for any reason, you can look through the library, I believe, and find that very interesting the last time, so worthwhile looking at that. What I'm going to do is I'm going to hand you over to Ian Quayle, who's got an interesting number of topics for us today, and I would encourage everybody to put a hand up or interject or however interrupt us if you've got any questions or comments to make. Thanks very much.
Thanks, John. Thank you, and good afternoon, everyone, and welcome. A massive thank you, as ever, to Stewart Title, John, Liz, Robert, and the team at Stewart Title for organising these events. Without them, this opportunity to get together and chat about topics wouldn't exist. Just a reminder, I have some, as John mentioned, I've got some topics that I'd like to explore, but at the end of the day, this is your event. So I will be looking in the chat all the way through today's event, having a look at any topics that people would like to raise. The other thing to be aware of is that if you have any topics that you'd like to explore on the next occasion, or you'd like speakers to come along to the next occasion, then drop me a note or drop John or Liz or Robert a note, and we'll endeavour to arrange that. And on the topic of speakers, I'm delighted to say that we've got a gentleman called Aidan Young with us from Dye & Durham. Dye & Durham are a search provider based primarily in Canada, but with a presence in the UK. And I'm delighted to say that both Stewart Title and ourselves do a lot of work and have done a lot of work with Dye & Durham over the years. So, Aidan, I don't know if you can hear me.
I can indeed.
But we can certainly hear you. So welcome, Aidan. Can you just explain a little bit about your role in Ireland? Obviously, you are a search provider, and I assume that you're willing to travel to see firms to explain to them your services, etc. But if you wouldn't mind just sharing with us for a few minutes a little bit about what you do and about what you can do in connection with searches for our Northern Ireland solicitors and conveyancers.
Yes, well, thanks very much, everyone, for letting me take part. As you're saying, my name's Aidan Young. I'm the operations manager at Dye & Durham, formerly known as LawLink NI. So a lot of people still refer to us as LawLink NI. We're based in Belfast in Northern Ireland. And don't worry, I'm not here to give you any kind of sales spiel of any kind whatsoever, but I'll just give you a little bit of information on us and then explain why I'm on here today, because we have some exciting news that we'll probably be able to announce that's going to be happening shortly in probably early 2025. So as mentioned, we are now Dye & Durham. We were acquired by Dye & Durham in 2021 as part of their global expansion program. Dye & Durham themselves are a leading legal software company. They have offices in Australia, Canada, South Africa, England, Wales, and Ireland. We were formerly part of Rochford Brady in Dublin. They've also acquired Rochford Brady too. So we're now part of a very much larger company, and they offer a wide range of services, including accounts and case management systems to companies across the globe. Our job here in Belfast, we remain focused on supporting solicitors in the conveyancing process across Northern Ireland. But however, as part of the Dye & Durham group, we now have the capability to conduct international legal searches, which is particularly useful given the increasing number of sort of overseas property owners in the region. And you'd be surprised over the past 12 months just how many sort of external investors have property here in Northern Ireland. We're now able to assist on that as well, you know. In addition to the standard searches, we offer kind of unique services. We can actually process the local authority property certificates. We can order maps, ACE maps, land registry maps. We can conduct utility trawls. We can do searches, dial before you dig. So basically you can see if there's any sort of contaminated land, searches, those can be done as well. So really we can carry out all kinds of searches that sort of benefit the conveyancing process in Northern Ireland. But one of the main reasons why I'm on here today is that over the past number of months, and probably a lot longer than that, we've actually been working alongside Stewart Title in developing an online title indemnity shop, and hopefully that will be able to be launched sometime early 2025. We're hopefully on track to do that, which means then that sort of Dye & Durham in Belfast will be able to offer a one-stop solution, a one-stop shop for professionals working in conveyancing. Now, the online shop will allow you to, there'll be actually a title or a tile on our website. You can log on there, register your details, and then you can request your title indemnity cover. Any bespoke, any sort of strange kind of request, there'll be a dedicated email address. You can actually email in and give your the information in the background and that, and you'll get a quote back there as well. So we've exciting times working along with Stewart Title. We appreciate all the work that Liz and Stephen Smith and the team have done over the past number of months to get to this stage. And as I said, hopefully early 2025 we'll launch that online shop for any title requirements. But as far as the searching side of things goes, there's very little in the searching conveyancing process in Northern Ireland and further afield that we cannot assist on.
Brilliant. Aidan, thank you so much for that. Aidan, if you don't mind just answering one or two questions. First of all, could you put your contact details in the chat box there? So
yes,
that people, your email address, if people want to contact you. And Aidan, if you wouldn't mind, when you go live with regard to this exciting expansion of your business in 2025, again, would you come along and just perhaps do a demonstration to show people what you can do with regard to searches and title indemnity insurance? I think that would be really interesting and really useful.
Yes, that's one of the things we can do. I mean, my role started here with LawLink back in 2018 in business development, so I'm used to going out or visiting clients, going around them, showing them how our setup works, what we can do.
Brilliant.
So yes, certainly if anyone out there requires any sort of assistance as far as what we can do and wants somebody to come along and talk to their team as to what we can do for them, then I'm more than happy to do that, to be honest with you.
Brilliant. Thanks, Aidan. And thank you so much for your time, and appreciate your assistance and guidance, and we'll be in contact. So that's fantastic. Okay, so I'm sure Aidan will put his details in the chat box there, and we'll have a look at those, or alternatively, we'll make sure that it's mailed out to everyone. Remember, we do record today's event. You can see copies of slides, etc. We can get those sent out to you. And if you want information about Stewart Title product, etc., again, contact John, contact Liz, Robert, Stephen and the gang, and they will make sure that you're provided with all the information that you need. So first of all, contacts. There's Elizabeth's contact details and John's contact details from Stewart Title. As an event coordinator, there's my details. So again, I repeat, if you want things discussing, if you want topics, if you want speakers along for future events, let me know and we'll do our very best to organise it. As usual, I have some topics to explore today. And the first thing I want to explore today is something I'm very proud to say. I do a lot of work with professional indemnity insurers, and they're kind enough to share with me data and information concerning recent claims, etc. And I thought I'd just share some of the things that they've been sending to me recently, which are indicative of the sorts of things that are generating claims and creating problems. Thanks, Aidan. Aidan's details are in the chat facility there for anyone that wants them. So some of it is of no surprise whatsoever. Others on this list that is on the topic sheet here, I think, are surprising. First of all, what causes negligence claims? Well, one of the things that I haven't mentioned on here, but one of the things that they have spoken to me about is issues associated with stress and ill health as far as staff is concerned. So again, we're under pressure. There's loads of work to do. We're under pressure with regard to billing. We're under pressure with regard to clients. And there's, of course, the transactional stress as well. Do we look after ourselves and do we look after our colleagues? So again, this applies across the board with regards to fee earners and supervisors and all members of the team, just keeping an eye out, because what insurers say is where there is stress, where there is health resulting from stress, that can lead to negligence claims, which is fairly obvious, isn't it? Lack of supervision of fee earners is an issue. Buyer-funded developments. I want to share this with you. Aidan was mentioning the fact that you will be doing work probably on an international basis as well as work in Northern Ireland. One of the things that insurers are worried about, and one of the things which led to a large number of claims, and I'll tell you where it was a hotbed of claims, Liverpool in the northwest of England, buyer-funded developments. So you have a developer that can't afford to develop a site, but basically exchanges contracts off plan in the full knowledge to everyone concerned that the deposits will be utilised to facilitate the construction, the development. And lenders have taken some big hits with regard to this. Professional indemnity insurers have taken a big hit with regard to this, and they're still flagging this up as an area of claim. So do be careful whenever you're acting on behalf of a buyer or an investor who's buying into a scheme or a development that's not constructed yet. You know, what's the basis of the scheme? What sort of protection does your client have in the event of the scheme failing? The next thing that they mention is seller identity fraud, and again, still an issue. Dreamvar, Purnsing cases in England that were very famous, where seller identity fraud generated claims being brought against conveyancers. Those types of claims are still arising. And again, I was just looking yesterday at issues with regard to property fraud. How many of you, I'll put it to the room, again, please answer in chat, how many people here would highlight to a buyer client the risk of seller identity fraud? And how many of you would actually assess this as a risk with regard to the conveyancing transaction? It's not a huge risk, but it is nonetheless a risk, and Stewart Title do have a policy that can protect clients in circumstances where loss is sustained as a consequence of seller identity fraud. I note that you could register an inhibition or something of that nature on a title to try and avoid fraud. And I also noticed that the Law Society of Northern Ireland has some guidance with regard to fraud avoidance. Anyone got any comments to make with regards to that, or any issues arising from that? Would you advise me of the need to lodge an inhibition in connection with a concern I might have relating to fraud? Particularly here, I'm thinking about buy-to-let investors. I'm also thinking about clients that perhaps have land banks, etc. In those circumstances, you know, what are we going to do and how are we going to deal with it? Next thing, cyber-related issues. Again, you know, commonly encountered, and just be aware of it, please. Make sure that what we're doing is protecting ourselves and our clients with regard to cybercrime. Major problem, major issue, and insurers are continuing to flag this up. Then we'll drill down and start talking about some of the things that sadden me because they have been encountered since the year dot. Lack of file notes or written communication. I was speaking at a conference yesterday, and again, just explaining to clients, explaining to lawyers, when dealing with co-owners who are purchasing property in common with others, it's absolutely essential to make sure that we are communicating with all of our clients. So I was talking to someone recently who was acting on behalf of an association of clients that had clubbed together to buy an online property that was being sold online at an online auction. And again, the important thing here is there were 4 or 5 clients that were basically instructing the lawyers concerned, and the lawyer really was only dealing with the client that was actually bidding on the property. Be aware of that and make sure file notes are complete, particularly where clients are taking a view and are happy to proceed despite risk that you've drawn to the client's attention, or where there are issues outstanding, perhaps a search result that's come in that requires further clarification or further work on your part, and the client is saying don't bother with it, just proceed in any event. In these circumstances, it's important to make a full and detailed file note and to make sure that the client is aware of the risks associated with what is being suggested or what the client is happy to proceed with, notwithstanding the fact you've warned or given the client advice concerning risk. So again, can I just ask people, Alex and Aine, etc., what you would do in a situation such as that? The key point here is if there are outstanding issues where clients are wanting to proceed and that wish or willingness to proceed is contrary to advice, what do you do? How do you cover it off? Don't be frightened about asking clients to sign file notes or attendance notes. If you've had a telephone call with a client, make a note of the attendance, send it to the client and email it across and say, look, I've made a note of our recent telephone conversation. Can you confirm it's a true record? And again, getting a client to sign an attendance note might be important and might be reasonable. So file notes or written communication. I can show you case after case where lawyers have successfully defended negligence claims on the basis that the file is in top order with regard to recording meetings, recording attendance notes, recording telephone conversations, and then emails going to the client supporting what was said, explaining the position, and indeed highlighting risk. Inadequate or incomplete reports on title. Do you all have a model form of report on title? Again, there was a debate on LinkedIn just recently about how you report on title to clients. Do you provide the client with interim reports as due diligence progresses? Do you provide the client with one report on title just before you're due to exchange? How do you do it? Does the firm have a standard form of report entitled, and does everyone in the firm use that report? Again, recently I did some work for a firm basically looking at their reports on title and trying to amend and alter the reports on the basis that the firm was now going to do Building Safety Act related work. And the firm's told me, honestly, look, we've got 6 officers and we have 6 different forms of report on title, one for each office. But then when I actually delved into the matter a little more deeply, each office had fee earners that had different versions. So it transpired that there were nearly 30 different versions of the report on title that that firm was using. Now, that's a nightmare. It's a nightmare from a certainty perspective with regard to files being handed over from fee earner to fee earner. It's an issue with regard to professional management, and it's an issue with regard to professional indemnity insurance. So standard form of report on title. I don't mind whether you just produce one report before you exchange or you produce interim reports on title. The one point I would make here, however, is this: where you are producing reports on title to the client, make sure the report is consistent with the retainer, with what the engagement letter, what you've agreed to do for the client from the outset, and make sure the client acknowledges receipt of a report on title, acknowledges that it's been read and understood. All of those things are so important in my view. So please make sure you do that. And when we talk about inadequate or incomplete reports on title, when I had a sort of a deep dive into what insurers were getting at here, during due diligence, if you spot an issue or identify an issue, it is absolutely imperative that that issue is referred to in the report on title, and either how the issue has been resolved, or alternatively explain to the client that the issue remains outstanding, has to be undertaken. The fact that an issue has arisen during the transaction or as highlighted by the client during the transaction, it's not covered off in the report, is going to be very dangerous indeed. Again, the important point here to understand and appreciate is things like climate change reports. Again, in England and Wales, clients should be advised of the availability of a climate change report, where the client has had that suggestion or that guidance, and the client says thanks but no thanks, then in the report on title should refer to that fact. Where clients have been directed to inspect target property, the client should be directed, if they see anything during inspection, to report to you what they see. Then the client who has inspected and has come back and said there's nothing to report, there's nothing of concern, that should be dealt with in the report on title as well. I've instructed you to inspect the property, you've told me that you have inspected the property, and you've told me that nothing was drawn to your attention or is of concern to you as a consequence of that. I'm going to show you a case where that potentially was an important issue in a moment or two. Failure to act in accordance with lender requirements. Be careful with lender instructions. Someone showed me some staggering data about lenders changing their instructions. Again, important that you check instructions on receipt of instructions, but you also check instructions during the life of the transaction, because lenders are not adverse to changing instructions. Frequently, the instruction will be of little or no consequence to you, but it could be of significant consequence. You need to be aware of it. You need to be able to deal with it. Failing to carry out or recommend necessary searches. Well, this is interesting, with listening to Aidan a little earlier. I seem to have a sort of a bit of a falling out with the legal profession at the moment concerning searches for this reason. I don't think there's such a thing as usual searches. I think there are essential searches as part of the conveyancing process. I think there are searches that should be recommended given location of property, given client objective, given nature of property and nature of transaction. But one of the things I'm concerned about is the fact that a search provider may have a whole raft of searches that could be undertaken in connection with target property, and you're not telling the client as to their availability. Now, can I tell you, the resistance I get from conveyancers and solicitors is this. If we say to clients, look, these are the searches that we've got to do, but here's a list of other searches that Aidan and his colleagues can do for us, is there anything on that list that you'd like us to investigate or deal with or obtain on your behalf? Firms are saying to me, number one, clients are going to start asking questions about, what about this search? What does it mean? What's an agricultural search, for example? And they're also going to balk at how much extra it's going to cost to do all of these searches. So what firms say to me is that we don't want to tell clients about every conceivable search that could be undertaken in connection with this particular property. And I get that. I fully understand it. The sort of accommodation that we've reached is that I think you should be saying to the client, I'm raising inquiries, I'm undertaking searches on your behalf. Are there any issues that you would like me to investigate further? Because there are other searches, there are additional inquiries that I may be able to raise on your behalf in order to cover off or deal with those additional issues. So can I ask the room again, what would people do with regard to that? With regard to searches, would you say to a client, look, these are the searches I've got to do, but there may be other searches that Diane Durham and Aidan and the team can do on your behalf? Or would you just leave it and say, no, these are the searches that I'm doing? Again, I just think clients need to be aware that there could be other things or other steps or measures that you can do to assist the client. But I'm very interested in what your view is. And I quite understand that, if you're operating on fixed fees, you don't want to be saying to the client, here's a list of all the other searches that we can do, on the basis you're going to be bombarded with questions or inquiries. Or you're going to have clients that are sort of terrified that they can't afford to have all of these searches done, but that you're sort of intimating that they ought to be done. Again, I'm very interested in your views. By the way, no one has yet in chat raised any topics they'd like to discuss. And again, I just want to emphasize, the whole purpose of today is not for me to drone on for an hour about topics that I think are important. At the end of the day, I'm irrelevant. The issue is, what do you think is important? And I have to tell you that we do these forums in all manner of different jurisdictions, commercial property, resi property, Scotland, England, etc. And it's amazing how often people will throw questions or issues into the mix, as it were, during the forum, and how frequently colleagues are able to provide answers or solutions, or we can generate really interesting discussion points and hopefully reach or draw conclusions relating to the issues that are being discussed. So while I'm waiting for people to put topics into the chat, I want to just carry on with this list, if I may. Failing to make or follow up on inquiries and to advise clients of results. Again, basic stuff, isn't it? You'd think people wouldn't be falling foul of claims in these areas, but they are. Where inquiries before contract are raised, are inquiries being satisfactorily replied to? Are there any outstanding issues? Do replies warrant or justify further investigation? A seller that advises that there have been disputes with neighbours, for example, a seller who advises that a boundary is moved or something of that nature, would immediately warrant further investigation and further inquiry. So we're just talking about inquiries. There was a case in England called Rosser against Pacifico. I'll just put it in the chat box, if that's all right. Don't know if you've seen this case. Really, really interesting concerning inquiries before contract. And what the court was saying was, if a seller is going to respond to questions, then they are obliged to make reasonable inquiries before they answer them. In other words, if you're being asked about building regs or planning permission, there's an expectation that you've undertook investigations to determine what the planning status of the property is, what the status of building regs are, etc. If you're asked about whether the central heating system works satisfactorily or otherwise, then you're under an obligation to test or check it. So it's quite an interesting case that highlights another case called William Sindel PLC against Cambridgeshire County Council, which you may be aware of, where again the court said if you're giving legalistic types of reply, there's an implied warranty that you've undertaken or made reasonable investigations. Are you all familiar with that? Alison, have you read about that case or the old case of William Sindel PLC? It's again, I think, important to say to a seller, look, if you're answering replies to inquiries before contract, or if you're answering questions that are being generated by the seller, then you're under an obligation to make reasonable inquiries, undertake reasonable investigations before providing a response. In Rosser and Pacifico, the judge said conveyancers and clients alike need to understand the significance of inquiries before contract. Namely, that the seller is in an ideal position, given it's their property, to know about the property, warts and all, and that the idea of inquiries before contract, in whatever form they are, is that the seller should be sharing that information with the buyer. The seller should not be concerned about saying things that are detrimental to the property that could impact on the potential to sell the property, but should answer questions honestly and frankly, and that the principle of caveat emptor is sort of limited in scope or reduced in scope, courtesy of inquiries before contract. So in other words, you can't say, well, I don't have to answer these questions, or I don't have to answer them honestly, because you're going to have a survey, or you're going to inspect the property, or your solicitors will be performing due diligence. Everyone aware of that? And again, I would just be careful when I'm acting for a seller, what I say to the seller client about how they answer questions, because Rosser against Pacifico, although an English decision, has relevance to Northern Ireland and sort of highlights the fact that, in essence, the seller is under a duty or owes a duty to the buyer to provide full and frank replies to questions that are being asked. Really, really interesting stuff. And I'm warning seller solicitors about sellers needing to be aware of this fact. I'm also saying, as I've always said to buyers solicitors, buyers should be using inquiries before contract as a checklist to satisfy themselves with regard to the property. Okay, next point, failing to require charges to be redeemed or ensuring charges are redeemed. You've got to be kidding. In 2024, we're still dealing with some basic points, but insurers in their recent sort of guidance to me are saying exactly that. Priority periods for searches being missed, incorrect or improper advice on SDLT. Really interesting stuff, this one, isn't it? Again, with regard to SDLT, it can get really complicated, can't it? And if it can, you're perfectly entitled to seek specialist advice relating to it. Does anyone use any external resources for SDLT in complex transactions, mixed-use buildings, this sort of thing, mixed-use properties? Anybody? I don't know whether in Northern Ireland there are any entities that are providing this assistance, but there are a number in England and Wales that are doing so. And certainly, as far as conveyancing is concerned, you are under an obligation to tell your client about basics with regard to SDLT liability. But where a transaction is complex, the client should be advised to seek specialist advice, and that specialist advice ought to be paid for. The other point I think that's important with regard to SDLT is, at the end of the day, you're relying on information being generated by the client. So the client, again, has to be aware, this is the buyer this time, has to be aware of the importance of their providing information to you in order that you can give appropriate advice to them concerning SDLT liability. And again, there's been an interesting case today just reported on SDLT liability with regard to what is a dwelling, and where a property was sort of semi-derelict, and whether it still was classified as a dwelling for SDLT purposes. If anyone's interested in that, there's loads of guidance on the HMRC website, but there's also quite a lot of case law on that very point. The other thing to mention, I've looked at a couple of cases, and I just wondered whether anyone has seen these. Have you seen this case of Murphy against Doyle that I mentioned? The citation is on the slide there. Anyone seen this or looked at it? It's a sort of a lesson in what can go horribly wrong. So I'm just going to pull up the details. And what you had really was an absolute nightmare concerning a conveyancing transaction. And there was a conveyance of land, but everyone got themselves into a real mix up in connection with just what was being conveyed and then what was subject to first registration. So there are a number of points here that I want to extract from the case as from a practical perspective. Point number one, essential when we're drafting a conveyance, when we're drafting transfers, when we're drafting contracts, and when we're preparing plans, our client needs to see what we're saying, needs to see what's been drawn, and needs to check that what we're describing or what's been drawn on a plan is consistent with intent. In other words, where we're drawing a plan, where we're describing a plot or part of a plot that's being sold, are we comfortable that what we've described or what we've drawn or has been drawn for us is accurate? The seller needs to have a long, hard look at what we're drafting, what we're drawing, before it goes to the other side in point. The next thing to understand with regard to this is that, again, it is important when we're submitting an application for first registration that, again, our client, the buyer this time, sees the documentation and, again, that inspects the land and checks that what we are registering at the land registry is in fact what we own. Interesting in this case is that there was a important referral to the Rule 11 of the Land Registration Rules Northern Ireland 1994, requiring a solicitor to certify the following on an application for first registration: that the solicitor has investigated the title fully, that all necessary searches and inquiries have been made, and that all material information has been supplied. Well, the point in this particular case is that those three obligations were not met by the solicitor. And I think the important point there is that as far as the conveyancing process was concerned, there was a degree of reliance on the client with regard to this information. Again, important to understand the position with regard to your obligations as a solicitor or conveyancer with regard to an application for first registration, and a failure at the first hurdle to identify what's being sold from the seller's perspective, or for the buyer to be aware of what he or she is purchasing, can then lead to problems or issues with regard to application for first registration. The next thing that was interesting in this case was the Land Registry's powers of rectification. And it's quite interesting, this, because I do a lot of work with the Land Registry in England and Wales that has a similar power to rectify. And again, as far as that power is concerned, it is wide-ranging in scope and extent. But in this particular case, the interesting thing was that as far as the rectification point was concerned, in your regulations, there's a specific provision that says the register shall not be rectified in subsection 1 so as to affect the title of a registered owner, unless such rectification can be made without loss or damage to any person claiming for valuable consideration and in good faith through such registered owner. Unless the registered owner, or as the case may be, a person claiming as aforesaid through the registered owner or anyone else on behalf of either, has by his act, neglect or default been in any way responsible for or contributed to the error, or in the case of an error made before such registered owner was registered, he was aware of such error, or in the case of an error made after such registered owner was registered, he or his solicitor became aware of such an error where the error was capable of being rectified. In England and Wales, the registered proprietor or registered owner has a right of veto with regard to rectification. that right of veto can be lost where the client has behaved unreasonably, or where interests of justice require the title to be rectified in any event. The important point here is that there are duties that are imposed on the conveyancer and on the buyer during the registration process in an application for first registration, and non-compliance with those duties and obligations in Northern Ireland can lead to the same consequence. The fact that the right of veto, as it were, or the general principle that the title won't be rectified can be lost due to poor conduct or failure to comply with, was it Rule 1 I said a little earlier? Yeah, I think it was. So again, it's a really interesting case in that it explores rectification and applications for rectification. Can I ask the room today, has anyone made an application for rectification of the land register? And anyone encountered what the court's attitude is with regard to such an application? Anybody? Really interesting point. Again, land registries throughout the United Kingdom, Scotland, England, and Northern Ireland seem rather reluctant to rectify titles. And the reason is quite simply that they're worried about indemnity claims. So if, a title is rectified and someone later comes out of the woodwork on the basis that an interest in land that they have has been affected by rectification, they theoretically would have a claim against the land registry as a consequence. Okay, so anyone ever encountered that or had any dealings with it? Have you all seen that case, by the way? Again, I'll just put the title in the, the title's on that sheet there, isn't it? Murphy against Doyle, okay? The other case that I was looking at recently was a case called Dixon against Sharkey, a case involving beneficial interest. Have you seen this one? And again, a really, really interesting case, just highlighting some of the problems that can arise with regard to conveyancing. And here, the issue was that there was an agreement between parties as to co-ownership, and an agreement that one of the parties was to sell a property and utilize the proceeds of sale to carry out works and alterations relating to a property that was being acquired. And there were sort of estoppel arguments being raised and all manner of different arguments being raised. But the reason that I mention the case is that the court undertook an exercise to try and determine beneficial interests. Normally, the starting point with ascertaining the beneficial interest in a property is to look at the deed, the title deed, conveyance or transfer, to see whether or not that specifies how the beneficial interest is held. Only in exceptional circumstances will the court look behind that deed or document. So the important point is where parties are agreeing something that is inconsistent with the deed or document that you're drafting, the client needs to be warned as to the fact that actual contributions, as opposed to how the beneficial interest is stated in the conveyance or in the transfer, will be an irrelevance. The document normally prevails unless there are exceptional circumstances. Where there are agreements to make additional contributions towards the property and there is a failure to comply with those agreements, etc., again, as in this case, that could prove fatal. So where a party is promising to sell a house and utilize proceeds of sale to fund development work, etc., relating to the property that's being acquired, the fact that that promise or that assurance isn't complied with or isn't met can create problems or difficulties. So it's a really interesting case. And the other thing that I think is really interesting in this case is the fact that it highlights an important point that I want to share with you. Where parties are sort of splitting up or separating, it's important to understand and appreciate that if they exchange emails, and in that exchange of emails they agree or state what is to happen to the beneficial interest in the property, then that statement, those emails can be sufficient to constitute a transfer of the beneficial interest. So not decided in Dixon and Sharkey, decided in other cases, but Dixon and Sharkey sort of emphasising some of the problems with regard to beneficial interests and transmission of beneficial interests. Again, in this case, quite interesting looking at the judgment, the court tried to ascertain what was intended by the parties, and the court concluded that the idea was that the property was to be transferred into the joint names of the parties, but on condition that there was to be an equal contribution in terms of capital from both parties. And again, the court emphasising the significance and importance of that. 2 or 3 other things with regard to this. When you're acting for co-owners, as I've mentioned to you before, remember that co-owners are not a collective client, they are individuals. And therefore, you've got to deal with the clients as individuals. Potentially here, on receiving instructions from the 2 litigants, you could argue that there was a conflict of interest. And where there's a conflict of interest, really you should be advising the clients to go away and to come back to you when they have a common intention with regard to what's being done, or your instructions from both parties are exactly the same. Where that isn't the case, there is always a risk of a conflict. And again, I've seen this in a number of cases over the years. An aggrieved party who loses out when a property is sold will often then have a go at their solicitor or conveyancer on the basis they will contend or argue, I wasn't aware of the significance or consequence of what I was doing in instructing you to draft a transfer or draft a conveyance in a particular way or on particular terms. So do watch out for that. The other thing that I think this case highlights is the need for questionnaires when you're dealing with co-owners or people that are buying property collectively. What's your contributions? What are your future contributions going to be? What's been agreed? What's to happen with regard to the property where relationship breaks down, where commercial or business relationship comes to an end? This sort of thing needs addressing and needs dealing with. Again, can I ask, would you use a sort of co-ownership questionnaire if you're acting for people like in this case who are intent on buying a property together? Have you got co-ownership questionnaires that you use? If anyone hasn't, drop me a note, because I've got a very interesting one that was prepared by a barrister years ago, a barrister from Stone Chambers, no, 3 Stone Buildings, sorry, and it's quite useful. It doesn't mind it's being shared with. Again, having information and documentation on file showing what parties' actual contributions are and what their intentions are, I think really, really useful. To try and ensure that where, as in this case, a party doesn't get what they expected to get out of the sale of a property that's jointly owned, to try and prevent or to try and generate a defence to any allegations of negligence that are made against you. So that's the case of Dixon against Sharkey, a chancery decision that, as I say, not particularly lengthy, not particularly fascinating with regard to the law, but just highlighting issues, important issues that you need to be aware of and need to consider. Things that I've been working on the last few weeks, that, again, just to share with you if I can, it's some interesting case law concerning the Building Safety Act, not directly relevant to you in Northern Ireland, but one case in particular where a court, well, actually a first-tier tribunal, said there's government guidance ancillary to the legislation, the Building Safety Act. And this is where the tribunal sort of fired a shot against the bows of all conveyancers and practitioners. It is government guidance, it's not law. So it's not judge-made law, it's not statute or regulation. It is a government department opining what they think the law is. And what the court said in this particular case is they've got it wrong. So again, I think important where you're seeing any form of government guidance sitting behind legislation, be aware of it and be aware of its sort of volatility, its lack of sort of credibility, and just proceed with it on that basis. So I've exhausted my topics for today. Does anyone have any things, any burning issues that you'd like to talk about or to explore? On sales of parts, just going back to Murphy and Doyle, or where land is unregistered, it's so important to make sure that the land is properly described. I can show you case after case where the courts have emphasized the danger of relying on plans and the fact that plans themselves are notoriously unreliable. And the reason is, going back to the fundamentals again, a plan will reveal a legal boundary, which is in essence a pencil line on the ground, and will convert it into a red line or a black line. It could be 1.5 meters, 2 meters in width. And the problem that we then have is we've got to try and identify a legal boundary within that 1.5, 2 meter strip. And that's going to be difficult, if not impossible. Again, there's been a raft of case law that I've been reading relating to this, and the courts are saying all along to identify legal boundaries, we've got to ascertain what was intended when the boundary was created. And hopefully when the boundary was created, there was a description of it that we can rely upon in 2024. Now, in the case of Murphy against Doyle, there wasn't really an issue with regard to the plans. The issue was plans and description not being properly revealed to seller and buyer, and their problems arising as a consequence of that. So it's all well and good lawyers preparing plans, describing property, etc. It's critical that the clients are aware of that description, aware of plans, etc., and that they're saying to you, yeah, what you've got is correct. If in doubt, walk the site, inspect the site. Insurers don't like it, but where you are worried, and in the case of Murphy and Doyle, there was justification for being worried. It's quite a complex site from what I can gather. Walking around it and just checking that everything was in order, it was important. Again, the interesting thing with regard to that case was that a sort of catalogue of errors at the start of the transaction led to further and further errors, culminating in an application for first registration that included land that was in fact registered under a separate title. So quite a bizarre situation and quite a bizarre process. Okay, other things that I would like to talk about, listening to Aidan about searches and about sort of international clients and international work. Again, do be careful about taking instructions from clients and risk assessing who those clients are. So, are you willing to accept instructions from clients in England or Scotland in connection with purchases of investment properties in Northern Ireland? Well, why not? But again, the fact that this is a distant client means that you do need to ensure that you are adopting a robust approach with regard to client verification. And the second important thing is that where a client is buying a property out of their normal jurisdiction, it's even more incumbent on you to explain processes. So, you might have an English investor that's buying property in Derry or wherever it might be as an investment property. They may be perfectly familiar with the conveyancing process and land law principles in connection with investment properties in England and Wales, but may not be aware of the differences in connection with Northern Ireland. Same principle applies with a client buying a property in Edinburgh or something of that nature. The familiarity with conveyancing process can lead to a relaxed attitude relating to the process. In essence, the client that's bought 5 or 6 investment properties in England, but's now buying his first property in Belfast or in Derry or wherever it is in essence a first-time buyer. We need to be aware of that and to understand it. Okay, what I'd like to do now is while I'm just waiting for topics to come in, because there still isn't anything on the list there, is just to draw to your attention Stewart Title products, which are listed on here, and to remind you of John and Liz's contact details, given the fact that they're here to help you and to assist you with regard to your title requirements. While I'm just showing you that, I just want to explain to you some of the work that I'm doing at the moment. I'm doing a lot of work for firms in connection with scoping the retainer, onboarding clients, and the engagement letter or email that's sent out to the client when new instructions are received. And that work involves a number of things, some of which I'll share with you. The idea that you are advising the client about what you're going to do, advising the client about the limitations associated with what you're going to do, and explaining to clients things, steps, measures, etc., that the client may think you're doing that in fact you're not doing. So the retainer is an ideal opportunity to set out the ground rules with regard to the conveyancing process. I think it's also important to upload or front load clients with information about the conveyancing process, your role in the process, the documentation that the client is going to encounter, the duties and obligations that the client owes with regard to that encountering. So, for example, where you are contemplating taking out defective title insurance on behalf of a client, does your client understand their duties and obligations to Stewart Title as an insurer when that product is taken out? Does the client understand and appreciate that what that product does is providing a solution amongst what potentially could be a number of different solutions, but that the problem, the defect in title, still exists? With regard to boundary issues, the points that I made to you earlier in this presentation, I think apply. Do clients understand the problems associated with legal boundary identification as part of the conveyancing process? Difficult, if not impossible, in most cases, to identify legal boundaries. Does the client understand what registration at the land registry does, the protection that land registration affords, the duties and obligations that you owe and the client owes during the first registration process? Again, just as in England and Wales, there's an obligation to disclose on an application for first registration any information that you may have concerning the title that is being subject to registration, so that the land registry is made aware of any problems or issues. Again, years ago, I dealt with a matter where there had been a boundary dispute that appeared to have been resolved years previous. Application for first registration, no mention made of that boundary dispute, despite the fact that the buyer, the applicant with regard to registration, was aware of it. And the fact that that hadn't been disclosed generated a problem for the buyer, because someone came along at a later date to seek rectification of that registered title. And the point I made earlier about the proprietor having a right of veto in connection with the rectification, that right of veto was lost due to the unreasonable conduct of the applicant in failing to disclose to the land registry the existence of a boundary dispute on first registration. Okay, again, I haven't had, and it's unusual, I've never had a situation where no one has said, I haven't got any problems. So again, last call for this afternoon, does anyone have any burning issues, etc.? Would it be useful for Aidan to come along and explain to you issues with regard to searches, or to visit your offices to discuss searches, etc.? What do you think about my attitude of saying to clients, look, these are the searches that we've got to do or we're going to do. Are there any searches, are there any inquiries that you'd like us to make on your behalf with regard to your purchase? And flowing from that, do you always ask a residential client what your objective is, why the client is buying this property? I think that's so important, and again, is something that's overlooked. So in the retainer, in the report on title, you should be saying to the client, you've told me that you're buying this property as a buy-to-let investment. You're buying this property on the basis that you're going to demolish the buildings that are currently on there and build something else. You're buying this property for your elderly relatives to live in. All of those purposes could have issues with regard to due diligence, and therefore it's important to sort of set them out right at the start. On the issue of SDLT, no one's answered this question either. Do you use external resources for specialist advice relating to SDLT? There are a few companies now in England and Wales that are offering that specialist advice, and there's always been lawyers that, again, sort of specialise in SDLT issues. And again, I think it's important to understand and appreciate that although you are required to have a basic understanding of taxation issues, with regard to a transaction, SDLT in particular. If a transaction is complex, then you can seek specialist guidance relating to it. There is a company in England and Wales called Compass that provides that service. I wondered whether there was anything of an equivalent in Northern Ireland. The last thing I want to talk about today is that we are still contemplating organising a conference in Belfast at some point in 2025. In a former life, I used to come to Belfast 2 or 3 times a year with central law training, and I used to thoroughly enjoy it. Used to really enjoy the delegates and the questions, etc., that were asked. And again, I'm really interested on behalf of Stewart Title and ourselves, whether or not there would be an appetite for us organising such an event. Again, I'm going to be talking to the Law Society of Northern Ireland about that to see what sort of support they have or what they think about it. I know this week, or was it last week, was the conveyancing week. Anyone tell me how that went? Again, I guess that is sort of drawing awareness to clients rather than providing sort of assistance or guidance to the lawyers. Arlene, hi Arlene. Usually ask the client the intention and respect of the property and don't seek, yeah, unless the transaction is unusual. I think that's exactly right. But Arlene, the question I'm asking really, and excuse my ignorance, is what sort of specialist guidance is there in Northern Ireland? Do you have barristers, or are there companies that are setting out or selling themselves as specialists with regard to SDLT? Is really what I'm asking. So I'd be interested to hear from that. And again, anyone else, what about this idea about having a conference? And again, topics for next time, please, just fire away. And as I say, within reason, we'll see what we can do. So I'm just waiting for people to add to that. While I do that, has today been useful? I'm conscious that it has been me droning on, and again, I apologise for that. All right, there is an accounting firm in Belfast that offer it. Right, yeah, okay, great. So have you used them, Arlene, or not? Or you just know of them? And again, while I'm waiting for Arlene there, in the retainer, you can say, look, we're going to provide you with general advice with regard to SDLT, but we're not SDLT specialists. Unless you hold yourself out as being a specialist, as a conveyancer, you are a general practitioner giving advice about the conveyancing process. So unless you hold yourself out as an environmental specialist, planning specialist, SDLT specialist, you're okay. But you can't evade giving general guidance about SDLT, as Arlene quite rightly says. The client needs to know that where specialist advice is required, then you can obtain it. Okay, again, be brutally honest. What do we think about today? Have we missed anything? Are there any burning issues? No one's told me about the Law Society's sort of conveyancing week. I'm assuming that it's, as I say, directed towards the consumer, the client, explaining about the services that conveyancers can offer, rather than providing training, etc., for firms that are offering conveyancing services in Northern Ireland. Okay, on that note, I think what we'll do is finish. But what I'd like to do is say, first of all, a massive thank you to Stewart Title for inviting me along. To thank you all, we've had some good numbers today attending, so thank you for giving up your time. Again, I repeat the point that if you have questions or queries concerning product, John and Liz at Stewart Title. You've seen in the chat that we have Aidan Young's contact details, and we've got them on our file and system, as does Stewart Title, and we'll invite Aidan to come along at events in the future. And my information on slide here, please, not the day before or the morning of the next event, but at any time in the intervening period between now and the next event, drop me an email with topics, or drop me an email to say, we'd really like someone to come along and talk to us about whatever it may be, and I'll happily do that. I've got a man who's really interesting, talking about drains and septic tanks, etc. If there is such a thing as a really interesting guy talking about such a topic. But I've got one, again, if anyone would like him to come along at some point, he might be interesting. Certainly if we're doing rural property acquisition or disposal, he might be a guy that's worthy of coming along. But, you know, I'm open to offers and willing to listen. On that note, ladies and gentlemen, thank you very much indeed. Have a lovely day. Stay safe. And again, there'll be another event in November. We'd love titles, love topics, love ideas for speakers. But in the meantime, thank you very much, Aidan. Thank you for coming along today and giving up of your time, and the same for everyone else. Thanks, everyone. Stay safe and speak soon. Thank you. Bye-bye.